Welcome back to the Global Council powered by One. I am Sabarna, and in today's topic, we are diving into a discussion that is reshaping the global business landscape, cross border tax disputes. And who better to discuss this with than Mr. Shailendr Ramsagur, the managing partner of Nolan Laws in Mauritius, who specializes in international tax and business structuring. Hello, Mr. Shailendra. Welcome. It is a pleasure to have.
Hello, Subarna. Same here. It's a great pleasure to share this podcast with you as well. We've been looking for that since a long time, but I think now the time is finally here, definitely.
Sure. So let's start off by you giving us a brief introduction about yourself, your firm, and your practice.
Well, on my side, I've done my bachelor in laws at the University of Mauritius itself, and then I've done what we call the Council of Legal Education in Mauritius to be qualified as a barrister. And then from there, I've been doing my masters in banking and corporate law at the Hertfordshire University of UK. Also, I've been doing my ACCA part time. Well, from my practice, I started on my own in 2014, 2012, whereby my office was in Port Louis. But gradually, with the evolvement of time and competition as well, Mauritius was a bit late in what we call now as law firms, all these technical aspect of the legislation. So finally, in 2008 or 9, the law was here. But still, it was still, everyone having their single office in chambers in Port Louis. So in 2014, we created our law firm, which was on a different name previously. And then again, for the evolvement of how things are going out worldwide, we basically changed our name to Nolan's Law, which is a South African brand. And we are the founder of Nolan's Law in Mauritius, and we are the first Nolan's Law which exists around the world. Now, probably in the next few years, we'll be expanding in Africa as well. And yeah, so now that's how we are. We are Nolan's Law for over now, let's say 7 to 8 years now. Our main practice focuses mainly on all the stuff that we call the corporate law, which is the setting up of global businesses, taxation, cross-border taxation, and all those are provision of legal advice, which involve cross-border legal opinions. Even we dwell also into bit of succession laws, civil laws, matters, etc. But our main focus on the international side is tax and what we call the offshore, the global businesses, the setting up of special licenses in Mauritius. That's where our main focus is for the time being.
Okay, thank you for that. So let's begin at the very beginning. Cross-border tax disputes can be complex. The OECD guidelines have been instrumental in setting standards for international tax laws. But how do these principles get applied in real-world disputes, especially in the jurisdiction like Mauritius? And what are the most common tax disputes that arise in these cross-border dealings?
Well, for a start, let me just speak to you a bit about how Mauritius is. As many people would know, we were formerly the colonies of the Dutch, and then came the French, and then came the English. So basically, we've inherited a very hybrid legal system, which is a bit of mostly of French and English law. Like we've got on the French law, we've got all the aspects of contract, which is the Code Napoleon, and on the aspect of the English law, we have got all the procedures which we normally have, all the matters which are being dealt at the court level, like the procedures, the pleadings, and all that stuff. These are all based on English law. And coming to one thing which is very important again about Mauritius, we are what we call a dual state. Like for instance, we are signatories to many treaties in the world, but those treaties are not actually binding unless it is enacted for the parliament and it is made a domestic legislation. So that is one thing which many people don't know about Mauritius. Until these laws are enacted into the domestic legislation, they are not binding. There is no need to follow that. But still, even let's say we have a dispute which arises based on those treaties, even though it is not enacted in the legislation, the court will still look at the objective of the treaty, dwell a bit into the background to be able to give a more informed decision which will be binding over the years. But as and when this happens, the parliament here will enact those legislation and make them form part of our domestic legislation in Mauritius. For instance, that would be one of the which we're talking about, the OECD principle, which is per se not binding in Mauritius as it is not in the domestic legislation. But there are many aspects of this OECD principle which has been enacted in different part of the legislation. Like for example, if you look our income tax law, We've got the principle of arm's length transaction, which is one of the OECD principle, but part of which has been enacted into our income tax legislation, which there will be binding on all the companies and all the individual which has a residence in Mauritius, the tax residence in Mauritius. So I would say that the OECD principles are not fully incorporated into our domestic laws, but however, there are many parts which have been enacted into different parts of our legislation in Mauritius. So that would be for me on the OECD principle. Now, coming to the next question about how tax dispute are handled in Mauritius. Well, normally every tax dispute first is handled at the domestic level. At the domestic level, we've got a very good legislation which is called our Income Tax Act, coupled with the marginal Mauritius Revenue Authority Act, which is our main revenue authority. There is a very well established principle there. Like for example, you will have to deal first if there's any tax dispute with the authority. First of all, we'll have to deal with the tax authority itself within a delay of 6 months. There are informal meetings happening. They will request for documentation, evidence, etc., etc. Then we'll submit everything, and then there is a delay for them of 6 months to determine whether they will accept or not. Now, let's say, for instance, they do not accept the documents or the explanation that the taxpayer is putting forward. Then there is a possibility of what we call the assessment review committee. The taxpayer will have to make a representation before the assessment review committee. This is a very simplified procedure which is done online. So there is no need for us to go to the committee and file the actual hard paper. So we'll just have to file it online with all the grants and everything which the taxpayer believe has been wrongly dealt by the authority. And then at the assessment review committee, we've got a panel of one chairperson, which is normally a qualified barrister of over 10 years experience. And then we've got two panel members which have experience in tax matters. They may not be lawyers, but they might be accountants. They might be any other person which have a financial background, which they sit on that committee. Now, even if at the level of the committee there is no in the favor of the taxpayer, they still have the opportunity of going to the Supreme Court. But the Supreme Court will be on a very restricted matter. It's only on point of law. It is what we call by way of case stated. So there must be something which is very specific in the interpretation of those law which the Supreme Court will handle. They will not delve into the facts of the case itself. They will see whether these laws have been properly interpreted. Now, still following, if there is no favorable judgment for the taxpayer at the Supreme Court, they can still go to the Judicial Commission of the Privy Council, which is based in London, which is our final court of appeal. And this, for the 20 to 25 years, there have been very, very much many debates on whether we should be keeping the Committee of the Privy Council or whether we should be scrapping it. But at the end of the day, it is viewed as, from many investors or from many foreigners, it is viewed as something which is very, very predictable, very reliable. So Mauritius has decided to keep those which has helped in a certain way to increase the confidence in many investors which are coming to Mauritius, because they know whatever happens, they still got a ultimate court of appeal which is based in London, which in itself offers very much confidence in that from investors. Now we've got different types of dispute which probably are dealt at the level of treaty-based relief, which is Mauritius have got a number of DTAs signed with many countries. I think approximately probably we have around 45 which are active for the time being with many countries in Africa, England, Europe, France, etc., etc. So in the treaty itself, there are some mechanism which are provided, about how to resolve those tax dispute. For instance, the allocation of profits, the allocation of interest. So all that are normally already included in those treaties. But still, we still got different rules of interpretation, and still open for those people to come by way of to the court, or even in Mauritius we've got the International Arbitration Center now. So many people, the taxpayers, can also seek relief from this institution, which is working quite well for the time being, because even if taxpayers are based in other countries, they can still come here and do their arbitration in the center here. So that would be the main tax dispute which are occurring for the time being in Mauritius. Yeah, from on this side, I think that would be the main one. Just to add a very last one, since Mauritius is becoming very much like a global financial center now, with many people around the world coming to set up their industry here. Let's say, for instance, one company is having a doubt about a particular tax treatment, how to allocate that in their books, etc. there is a procedure at the level of the authority which is called a ruling. So let's say, for instance, you want to have a clarity on certain treatment of an item. You can write to the committee, explain the situation very carefully, and explain what you require from the authority. They will give you a ruling which is not binding, but however can always be used as, as persuasive manner, even if there is a matter before the court. Then we will follow those guidelines, the ruling issues issued from the authority, and this is published online, so anyone can get access to it. So if ever in the future there is someone else which got the same, which has the same predicament, they can always consult the ruling on the website of the authority, and they will find how this particular item is treated, and then they can always complete their books by following the same treatment which has been given by the authority. So to summarize, I think we've got a very good legislation here. It's very well defined, and I think if everything is followed well, I think there should be no problem in how to deal with tax matters in Mauritius. Thank you. Thank you for those insights. Like, I feel this is one of the reasons why we, look forward to doing these podcasts. Why? Because it gives us that regional insight into things, which, some of it is obviously available online, but then most of it comes from the expertise of, being in the region and practicing it on a daily basis. Definitely. Because we're in court like most every day dealing with those matters, so we're quite updated as well as to what are the new judgments that are coming on, and how the courts are interpreting the new legislation, whether there has been any previous judgment which has been turned over by the court and giving a new dimension, a new interpretation. So we are quite very updated with those what's happening before the courts of Mauritius. Right. All right, moving on. So, Mauritius is often also seen as the gateway between Africa, Asia, and Europe. So, it could be for the cross border trade, especially in tax structuring. So, how does Mauritius's legal system facilitate tax dispute resolution and support companies involved in international trade? So, could you also share how the Mauritius International Arbitration Center is utilized for tax related matters? Well, as I explained a bit earlier, Mauritius being a hybrid system, so we have the benefit of having a little bit of the French system, the English system, the common law as well. So basically, the International Arbitration Center in Mauritius do facilitate these disputes, which is based normally on two contexts. Normally, if you're talking at the level of pure tax, like we call the income tax or VAT, that would be dealt at more at the domestic level with the MRA, as we explained with the committee and all that stuff. But when it comes to investment related treaty, that's where the arbitration center will be a very good good use here. Let's say, for instance, if an African state normally imposes a retroactive gains tax on Mauritian investment, Mauritius being a signatory to what we call the IPPA, the Investment Promotion and Protection Agreement. We've got quite a number of those signed between countries. This will protect the taxpayer from what we call expropriation. Like, for instance, if there is a legislation passed in Mauritius whereby the government is taking the property of a foreign citizen, then he'll definitely have the benefit of going to that arbitration center to contest the decision of the government, which is what we call an investment-based treaty. Because if those foreigners are investing in Mauritius, they are protected by those investment treaties, which are just described as the IPPAs. So that would be one of the good help of the International Arbitration Center in Mauritius. Secondly, we've got contractual dispute with the tax with what they call a tax dimension. Normally, when contracts are being drafted, there are different clauses which are being put in the contract, but until and unless there is dispute arising, no one knows whether those clauses are actually legal, effective, binding. So, for instance, we can be having a contract whereby one of the parties may have put a clause about tax indemnity, but when the issue actually arises, the matter goes before the arbitration center here. We might be having a different ruling. So that's where I think the arbitration center is very useful in those tax matters, to be able to interpret those clauses at an international level by still having guidelines, having recourse to decision which has been made in other jurisdictions which have similar tax legislation as Mauritius. So I believe, yes, that since the inception of the center, it's been very useful in those tax matters as well in Mauritius. Right. Very interesting. Like, so far, what I've understood is that Mauritius is not just a tax haven, but it also provides very structured solutions for companies coming. Yes, no, Mauritius is not a tax haven, definitely not. Because let's say, well, which probably which missed out in the OECD legislation. Previously in Mauritius, the tax rate was 15%, flat rate for domestic companies. But however, for the global businesses, the tax rate was 3% only. That was flat. But then with the coming of the OECD, whereby we cannot have a discrimination in tax rate within the same country. They have upped the tax for the global business at 15%, but still we've got certain criteria whereby depending on the type of business in which the global business are operating, they can be obtaining an 80% relief on the taxation, whereby they can come back again to 3%, but it is not a guaranteed. There are certain strict criteria which has been established in the laws of Mauritius, whereby if you satisfy them, then definitely you'll be able to benefit from them. Like for instance, substance over form. Previously, many companies were just operating here, having a PO box, and they're okay. They are benefiting from the 3%, but now no, it's different. They have to show substance, their office. They have to employ people here. They have to actually show that the company is being managed in Mauritius and not outside Mauritius. So that's where we have adopted certain principle of the OECD guidelines as well. So basically, yeah, Mauritius is not a tax haven. That's for sure, definitely.
All right, very, very interesting insight. Thank you. Now, shifting our focus to the African Continental Free Trade Area. So, this is a massive agreement bringing 4 African countries together. How has this area really influenced cross border tax disputes in the region, and what are the main challenges that businesses are facing when it comes to tax compliance or tax dispute resolution within this new free?
Well, as we all know, the African Continental Free Trade Area normally has its focus mainly on tariff reduction and elimination of tariff among the member states. This would normally tend to reduce duties on intra-African trade between those member states. But still, there are many disputes which are still arising even within that area of the law. Because for instance, there are still disputes arising on the origin of goods, like to qualify for those preferential treatment, we have to determine where is the origin of the goods, whether it is basically within those members states, or whether they have been trying to use a loophole in those trade areas to put the product as being originate from those countries. So I believe, yeah, even though this is a good thing, but it's still quite new. There are many disputes which I've just mentioned. One which is the origin of goods. Probably over some time we'll also have disputes about the classification of the goods. How are they classified? The valuation of those goods, whether they are properly valued to obtain those preferential treatment as well. Even though this is becoming quite global, each country will still have their domestic taxation laws, which will still be under their control. So still there might be lots of disputes, conflict arising between those free trade area treaty and those domestic laws, which has not been resolved yet. But I'm sure probably with time they will definitely find some mechanism within those free trade area to settle those disputes. Even though the African continental free trade area does have its internal dispute settlement protocol, which is based on the WTO system, but still I would still believe that there is much to go, and there is much clarity to be brought to those free trade area, and even in the future, because it is not well settled for the time being. It's just being countries are now adopting it. So I think there is much work to be done again on that as well. Now, what are the main challenges for businesses using, which is based on those free trade areas? So we know what we call as a fragmentation of the tax system. Like each member state within those free trade area will still have their domestic tax laws, which might be different for what is provided in those free trade area. So if we look well, there is no harmonized system between the domestic laws and those free trade areas, because let's say for instance the free trade area might provide for a duty exempt on certain goods, but the domestic laws provide a double duty on that can arise definitely in within those and also that those challenges might also lead to an overlapping in tax claim and compliance burdens, because let's say for instance a country is member of that free trade area, and there are some compliance requirement within that trade area which is different from what is required in the domestic laws. So that's where we call, we'll be having overburdened tax compliance, which might lead to the fragmentation of this tax system. So I believe, well, it might be a good thing for those African countries. It still has to be much clarity must still be brought about this. How to implement that. What are those taxation system, tax dispute system, which is available. The problem might also have problem about transfer pricing, which might be different in different countries. How they view it, the arm length proposition, which is different in all those countries as well. So I believe there are lots of challenges which are here already, and many more challenges will be there in the future. But I believe that they will definitely be able to sort out and come to a more harmonized system within those free trade area.
Right. So in Crux, I feel with this new framework coming in place, there is more a open trade between the African countries, but then the complex tax regimes that are present, they
Definitely.
are presenting new challenges that are to be still met and seen in future. Right. So as cross-border tax disputes are becoming more prevalent, and you know how even African markets are continuing to evolve itself. So businesses must also be legislation ready. And how should companies then prepare themselves for potential tax legislations and litigations, especially in the context of cross border operation? So, what strategic steps can companies take in advance to mitigate the risk of disputes in many transactions, infrastructure investments, and also cross border projects?
I believe first of all, there's the need to have a good structure at the company itself. There must be a person which have very good experience in tax matters first, which know the system in and out, being at a domestic level or even at an international level. Like for example, let's come to domestic first. Like I mentioned earlier, if you're in doubt about something, about a particular treatment about a certain item within the books, then I think the company should always, anticipate of writing to the authority to seek that ruling which I spoke about. That would be in clarity, at least until there is a matter which is decided by the court. But the company would know, okay, we have a ruling from the authority, so we can follow that, and does those entries, or does those treatment as it has been in those ruling. Now, if we talk more about on an international level, I think one of the main areas for the time being whereby tax disputes are rising is on transfer pricing. So basically, I think the company should be able to maintain and detail their transfer pricing documentation very clearly, with clarity, and most important, it should be based on the OECD guidelines, because at the end of the day, we are all dictated by those guidelines. It's only a matter of time whereby we will be incorporating them in our domestic laws. So I think that would be one of the main thing about the company, to be able to to anticipate, to be litigation ready. Another example would be probably to keep proper documentation about what decisions are being taken at the management level, at the board level, to ensure that those decisions are being taken, whether inside Mauritius or outside Mauritius. Because one of the other tax dispute which is very common is the permanent establishment. Where is the decision actually being taken? So I think those board minutes, those documentation should be kept readily available if there is any tax matters in relation to those permanent establishment duties. Mm, and then probably there should be also a very good tax diligence to be done. As and when probably you should always write to the authority to say whether to seek information whether the company is compliant, whether the company owes any tax. That is just a simple thing whereby we can always mitigate those incoming tax matters, to see whether, for instance, there might be some stuff that a return might not have been filed, or the system at that time might be locked or something else. So it'd be good for them to do tax diligence, to still write to the authority to see whether there is any tax due, any those sort of things. And then probably the structure of the company, which we have always talk about. And most probably, I think all those contracts must be properly drafted. When drafting contracts now, it's no more on a domestic level only now. Even if two people are transacting in Mauritius, for instance, but still, we need to anticipate a problem which will go out of the domestic law. So I think when drafting those contracts, those clauses on tax, defining the proper law, defining the place of residence, defining the, like for instance, if there is a tax matter, where would that tax matter be heard? So I think all that must be properly defined into contract for them to be able to anticipate any potential litigation which is coming in their way. Sorry. So, right. What I understood is that
tax readiness isn't just about compliance, but it's also about anticipating the risks and understanding where the legal frameworks are likely to have a significant impact. Right?
Definitely, definitely.
So, looking ahead, where do you see the future of cross border tax dispute resolution headed? Like, particularly in relation to the OECD guidelines and the even CFTA, what advice do you have for businesses looking to optimize their tax structures and avoid legal pitfalls in the next decade?
Well, the future of cross-border taxation with the OECD guidelines, it's becoming, if you can say, it's like being imposed. We don't have any other choice than to implement that. For instance, if we have the BEPS 2.0. Like recently, people started talking about the qualified minimum top-up tax, which has been implemented in Mauritius in the last budget. Like for example, if you have a company in Mauritius which has a multinational around the world, like having a certain amount of turnover, so they qualified for a minimum global tax, which is as per the OECD guidelines, which is 15% in Mauritius. This has just been implemented in Mauritius. And, as well, for the African free trade, as I told you, it is in process, but I'm sure it will be gradually be tested in terms of custom duties and what we call of the origin of the goods dispute, which is becoming more and more a tax dispute nowadays. So I think yes, over time, this will be definitely be one of those areas whereby we might be getting more and more tax dispute. So I believe even those guidelines and those areas, those mechanisms, they'll have to make it in a more regionalized system of dispute mechanism, which is not that different from what we have in our domestic legislation. So that not to overburden those companies with tax issues, with tax compliance matters. So at least they know they have one mechanism which can be used for the domestic, and that's more or less the same one which is being used if they are members of those member state as well, which form part of those trade areas. Well, my advice would be for the next decade. For instance, like we spoke earlier, gone are those days where you set up a company with just a PO box. That's not working anymore. So I believe that companies must prioritize substance over form now. Like if they want to benefit from a particular relief in a particular country, they have to actually show that substance that they are operating there based they'll have to abide by those domestic laws as well. And then probably my next advice would be to be always ready for litigation, because whatever mechanism we may have, litigation will still remain at the center of everything. Any dispute, any legal matters, they say, okay, let's go to court. Like we always say, let's go to court. We'll see the matter in court. So I think all the companies must be always ready, prepared for the litigation. And as we discussed, this could be achieved by drafting very good clauses in their contract, everything. And also probably one of my advice would be also to be more in technology, data compliance, because with the concept of invoicing now, which is coming quite famous all over the world, where the authorities are monitoring everything. So I think it would be a good idea to invest in those technologies as well, to be able to be more compliant in the future. Because like we say, better to invest now in those technologies than to pay a bigger fine or bigger settlement at the end of the day. So better to prepare for it now, than at the end of the day you come up with a big tax case whereby you'll be paying millions to the authorities, and thereby the whole business will crumble at that time. So I think it's better for them to invest now on those technologies as well.
So it really comes down to strategic foresight then. The businesses that proactively manage cross-border tax risks will have a significant competitive advantage. And I believe through these discussions, hopefully businesses do not really crumble down and have
Yes.
huge tax cases. Thank you, Mr. Shailendra. This has been an incredible, insightful session today. It's been an eye opening discussion about how Mauritius is standing at the intersection of international tax law, business structuring, and dispute resolution in Africa and beyond. It was a pleasure to have you with us today.
Thank you. Just to add probably a last point, recently we've had the Prime Minister of Mauritius, which was on visit in India, and well, they have announced it that they have an agreement to make Mauritius becoming a financial hub. So I believe with the support of India now, over the next few years, we might really see that financial center, financial hub in Mauritius being developed at a very good speed now. So I believe, yeah, that will be happening in the coming years, definitely.
Thank you for leaving us with another point with a bright future. So this is the Global Council powered by One. I am Subarna, and today we had Mr. Shailendra with us here for the session. Stay tuned for more conversations on global business insights from leading professionals worldwide. Until next time, stay sharp, stay global.
Thank you. Bye bye.
Thank you.